School. So class from our program with Central High School. So I'm trying to integrate them into the conversation, but keep moving. We need to cover our material. So it's good we have guests, but that's where we'll do it. And since we're just starting on conflict, I think in that Tuesday class, I'll just briefly go over what we've been doing, and then we'll move into our discussion. And then after that, Steve Luxenberg, who wrote the book Separate, is really a tremendous book. I haven't finished it yet. It's big, but it talks about Plessy versus Ferguson, but takes a different historical approach. It has different vignettes about the justices who decided the decision, how it was argued, how it originated, and all of that. So it's really interesting. He's an award-winning author from the Washington Post, so he'll be here Tuesday as well. And that's after our class. Okay, so our goal today is to finish lawyer-client relationship, and then that's going to set up our entire discussion about conflicts. We're going to do conflicts a number of different ways. You're going to get tired of it, but from chapter 6 to chapter 10, we'll be talking about various conflicts. And when we get to chapter 6 today, we're going to be talking about concurrent conflicts, probably one of the more common kinds. We're going to take Rule 1.7 and look at that. We're going to try and figure out what directly adverse means, and we're also going to look at material limitations. So the reason we've spent so much time painstakingly going through the components of the attorney-client relationship is so that you'll see that there are a number of external things that can impact how you function as a lawyer. And it impacts competence, candor, communication, diligence, all of those things. And so you'll see over and over again that we have complex roles, and we have to be really firing on all cylinders. Sorry for the cliche, but we're balancing these rules of professional responsibility, any other rules of compliance. We have to be aware of the context. We have to be aware of our relationship with the client. We have to protect confidences. That's going to come up even again when we talk about diminished capacity to finish up chapter 5. So in our last class, we did the washing machine, and that was just to show you various levels of competence. Would have been perfectly fine to settle that case. That was the community norm. But doing a little bit more research would have helped your client immensely, and that's what the clinic students did in that particular case. So that was the washing machine problem. I think that was on page 196, I believe. Yeah. So what is competent representation? Then we looked at Strickland, starting on page 197, noted how highly deferential that standard is. Counsel was not functioning as counsel, and but for the counsel's unprofessional errors, the result would have been different. Did the error affect the outcome of the case? And we noted that Strickland really totally insulates a lawyer's strategic choices. But we also made a bright line distinction between strategic choices and issues that bear upon the competence of the lawyer. So one reason Strickland is deferential is what it wants to advance this knowledge that attorneys are advisors, counselors, we exercise independent judgment, we have to be candid to our client, we have to make sure we don't make misrepresentations to third parties. So we protect all of that, but at the same time, we have a client who has rights as well. So we're trying to balance that, usually in the context of the Sixth Amendment, where we say ineffective assistance of counsel. But if you look on page 202, 1, 2, 3, this fourth bullet point, it says even in the 5 years after Strickland, defendants prevailed in their claims of ineffective assistance of counsel in only 4% of the cases. So that's a very high standard. But then we looked at some cases, starting on page 204 and 205, where we showed that there was prejudicial impact because of what the attorney did. Padilla, we said failure to provide accurate advice to a non-citizen was ineffective assistance of counsel. Fry, failure to communicate a plea offer that lapsed, ineffective assistance of counsel. Cooper, defense counsel offered inaccurate legal advice that led the defendant to reject a favorable plea, ineffective assistance of counsel. And you notice running through those three cases, basic levels of competency were not met. You know, this is an attorney sort of making factual determinations. Oh, you only shot him below the waist, so that isn't murder. That's not the type of lawyering that you would need in this particular situation. So even with a deferential standard like Strickland, we still can find ineffective assistance of counsel. That's on page 204 all the way over to 208. Then a desire to investigate, we talked about, we said that here the client's constitutional rights were at risk. The attorney was perfectly within his rights of saying that I need more time to interview. This was an intersection between 1.1 competence and the Sixth Amendment. This is on page 209. The judge was wrong in saying that just move on with the case and you can bring an ineffective assistance of counsel claim because the burden is so high on the defendant, as we illustrated earlier, very deferential. And we noted that the attorney properly refused to put his client's constitutional rights at risk. And we also noted that this attorney was sentenced by this judge to 3 days in jail for contempt, but this judge had his own problems as well. He returns to practice, and we find out that under the Code of Judicial Conduct, this judge had failed to keep records, had ex parte conversations without opposing counsel being present, and so his license was suspended due to 10 violations of the Code of Judicial Conduct while he was on the bench. From there, we talked about candor and communication. We looked at Rule 1.4 on page 214. Then we talked about candor and counseling, emphasizing that the attorney has independent judgment. And then we looked at an issue of the scope of representation. Who calls the shots? We looked at Jones versus Barnes on page 229. And there we said, even though there's a personal right for a client to represent himself, there's no right to compel counsel to press non-frivolous points. Again, another deferential point. If the counsel has made a professional judgment that we're not going to press all of these points, you see that on page 230, the court said that is fine. The dissenter said, well, this is bad if there really is a constitutional right to proceed on your own behalf. What does it mean in a scenario where you have a criminal defendant with counsel forced upon him, and then also have that counsel ignoring claims that this criminal defendant wants to raise on appeal? What does individual autonomy under the 5th and 6th Amendment mean? That's on page 231. So that's where we left off. We're around page 235. 233, I should say, to 235. We're talking about diminished capacity. So look at this rule, diminished capacity. 1.14. 1.14. So if you have to look at that rule, this is the situation. We're going to be in this situation in a few minutes when we talk about the vinyl windows case, problem 5.3. But looking at this rule, what do you have to do as an attorney? First, tell me what this rule says, and then what is you as an attorney? What do you have to do? Diminished capacity. Again, this is one of those balance things again. It looks like you have to do two things at the same time. One thing you notice through this rule is we're really concerned with client autonomy. We're really concerned with the role of a lawyer and a client together. It's collaboration. And in order for this collaboration to be meaningful, there has to be give and take. We don't want to, because of our special powers as attorneys, just overcome the will of our client, so much so that we're running everything without listening to the client. That's why we emphasize communication, scope of representation, all of those things. So, what about diminished capacity? You see it on page 233. What do you, as an attorney, have to do under this rule? What do we have to do? Yeah. Ms. Paul.
You have to, as far as reasonably possible, maintain a normal client-attorney relationship, but then if it gets to the point where you think that they are in physical harm or financial harm or anything like that, then you can talk to anyone that kind of has control over them. So if they still live with their parents or something like that, you can talk to them about this.
Yeah. Is that always about, how do you do that though? Act like they're normal, but sort of a little bit concerned about their ability to make decisions. How do you sort of do that balance? Because I think you're right. There are 2 or 3 things under this rule. First of all, and I'll just sort of paraphrase this, the lawyer shall as far as, there's that word again, reasonably possible, maintain a normal, see that's a problem with me, what is normal? Normal client, lawyer relationship with the client. Now, so the first part of this, before the ellipsis, says, when the client's capacity to make adequately considered decisions in connection with the representation is diminished. So it could be a minor, it could be mental impairment for some other reason. The lawyer recognizes that, and then the lawyer shall, as reasonably possible, maintain a normal client-lawyer's relationship with the client. So notice this is a progression. First you try and act like everything is normal. Maybe you can do that within the context of your situation. But then, as Ms. Paula points out, if things occur and you know that this is impossible to maintain this normal relationship, you reasonably believe that the client has diminished capacity and is at some risk, substantial physical, financial, or some other type of harm, unless you take some action, then the lawyer may take. So notice this, reasonably necessary protective action. So notice how this builds upon, we don't want you to go overboard, we want you to be able to navigate this. The first thing you do is make an assessment and try to make sure that you can do everything you would do in a normal client-lawyer relationship, whatever that is. Failing that, and you know that there's some type of harm on the horizon, you take reasonably necessary protective action. And that's including talking to people, someone who has the ability to take action to protect the client. I think we mentioned parents, maybe even seeking the appointment of a guardian ad litem. So necessary, so I think what you want to really realize here is that the action that the lawyer takes is proportionate. You don't want to go over, oh, I don't think you can handle this, so I'm going to talk to social services, I'm going to appoint a guardian ad litem, I'm going to take away your decision-making power, and then I'll just deal with this person. we don't want to obliterate that. So the text tone here, what we're trying to preserve some level of client autonomy. Within this difficult set of circumstances. And then I'll just put 1.6 here. So notice, protect the confidences. So this is saying don't be careless just because your client may have diminished capacity. Information related to the client is protected by 1.6. When you're taking this type of protective action under 1.14b, the lawyer is impliedly authorized to reveal information about the client. So this is expressly saying in this rule that you can reveal confidential information. I'll just put impliedly authorized. Carry out the representation. But you want to emphasize that revelation is only that which is necessary to protect the client's interest. Only. So this means revealing just enough to protect the client's interest. So again, within this broad context of protecting client confidences, this is another exception where we're trying to help our client in a difficult time. So how do we do this? How do we maintain a normal relationship if we think our client has diminished capacity? First of all, how do we even know? We're not psychologists, so how do we make these determinations? And so notice, if you look at comment 1, it starts off by saying, there's a lot in here, but nevertheless, a client with diminished capacity often has the ability to understand, deliberate upon, and reach conclusions about matters affecting the client's well-being. So we're trying to preserve that autonomy. So even though we know a client may have diminished capacity, there may be some level where the client can still act as a client, and we should treat the client in that way. Another thing that is, I just said, client. And still be able to function as a client, despite Comment 2, see, all of this is going to autonomy again. Comment 2 says this, just because your client may suffer from diminished capacity does not mean that you should not make every effort to treat that client with attention and respect. So of course that means not being dismissive just because you may determine that the client has diminished capacity. So always looking to the client. Comment 3 even says, even if you confer with other family members or someone that can help you make some assessment, the lawyer must keep the client's interest foremost. Must look to the client. I'll just put keep client's interest foremost. To the extent possible. So another example of client autonomy. So all of that's fine if you are sort of trying to protect the client and keep this normal relationship. But what happens when things fall apart? How do you know when to seek protective action? Do the comments tell us anything about that? So I'm suggesting this. When we go down to 1.14b, we've made a decision that, as the comment says, a normal client-lawyer relationship cannot be maintained. So when we drop down to here, you're saying a normal, and this means you've tried everything. You've tried to navigate, a normal client lawyer relationship cannot be maintained. Mr. Madeline, you had your hand up.
Just pointing to comment 6 where it lists the factors for determining the extent of diminished capacity.
Mm-hmm.
And the theme seems to be like the client's inability to understand the consequences of decisions and be able to articulate like where they're coming from on what they want.
So I guess, and this is going to vary from case to case, but you have to make a determination about can this client function. And then it says the lawyers should consider and balance these factors. So you try to sort of, notice this, you can use the rules as sort of a test to see if your client can actually function. So for example, under 144, you're communicating with the client. You're advising within the scope of the representation. You're trying to have this give and take. And it seems like that cannot happen, at least consistently, or you reach a point where it's not happening at all. Then it's time to take protective action. So variability of state of mind, ability to appreciate the consequences of a decision, that could be very important. So notice if the client can't understand the consequences of a particular decision, that sort of erodes this notion of informed consent. Because you can give a critical assessment, but if the client cannot accept that because of diminished capacity, then you have a problem. There is no real effective attorney-client relationship. So you balance all of that, and you look at, it says in comment 6, long-term commitments and values of the client. In appropriate circumstances, the lawyer may seek guidance from an appropriate diagnostician. So there may be, and this is sort of like the last result, there may be a time when it's breaking down and you have to bring in a third party to this relationship to figure out what's actually occurring. So, what about comment 7? I just want to point that out. So comment 6 talks about assessing diminished capacity. 7 talks about the protective measures themselves. What about that? This is telling you may have to make an assessment about how far to go in having an appointment of someone outside of the attorney-client relationship. And it even says within the rule, you should try and advocate the least restrictive action on behalf of the client. So a conservator or guardian ad litem may be necessary, but you go through all of the least restrictive alternatives first, and if it has to be that way, then that's fine. But you should go through all of the alternatives that are available to you. So back to the book, if you look on page 235, there is a discussion about really lawyers in any context avoiding being too paternalistic. And in this article by Professor Tremblay, he argues that you should try to preserve client autonomy. And so to him, and this is his argument, guardian ad litem is legitimate in extreme cases. If you can rely upon a family, that might be the least coercive approach. Non-coercive persuasion is justified in less extreme cases. And he also argues that unilateral usurpation of the client's autonomy is never appropriate. So his entire article really talks about preserving client autonomy. See that on the top of page 237. I'm sorry, 236. Okay, now this last problem in chapter 5, vinyl windows. So the reason we talked about this, we can apply some of what we've been talking about to, all of what we've been talking about to this case. So go through the facts of this and sort of advise the client, if that is possible. Typical scenario, we have a 83-year-old client, Mary McCabe, widowed, living in this house for 50 years. House is in good condition. And we come to find out that she has entered into some type of contract with a window company. And it seems like the typical type of scam scenario. Doesn't really need windows, but she signed some papers anyway. Salesmen ask for money. Each time they come to do work, she continually goes to the bank to get money to pay for the work. The project is completed in quotation marks. The workers ask for a last payment of $900. Our client McCabe complains that the work isn't up to par. They've broken some things, shabby workmanship. She refuses to pay. There is a claim filed in small claims court in which this company, StormGuard, says that she agreed to pay $8,900, but never paid the final $900. So it seems like our client is a bit confused about how much money she's paid, has to pay. Documents are kind of shaky. When we ask to see the contracts receipt or other documents, her mind drifts and she just starts talking about She calls the workers those crazy boys. It seems like she likes the company maybe, and this could be her just having workers around so that she will have company and won't be lonely. That's a consideration. But she thinks that also that the installers may have stolen $400 in cash that she had lying around. So we have some options. I think we need to think some options. One thing that we know is that the lawyer for StormGuard is a settler. He just wants to settle things. Since we owe $900, the settlement price will probably be $450. And he usually takes this course, and she could probably move on for $450. And so these options are laid out on the top of page 238. You could pay the full amount. We could settle, wait until trial, be prepared to accept an offer of $450. We could defend vigorously, because just like in that other case where we checked and found out some things about the washing machine contract, probably the same thing can happen in this particular case. We could have defenses on duress, unconscionability, misrepresentation. You see that on page 238. Maybe we get aggressive and counterclaims based upon poor workmanship, damage to the wall, not being licensed as a contractor. Or maybe we just do sort of a status quo type thing, just get the company to repair the windows and we'll leave it at that. We'll move on. So those are our options, and it seems like she understood that we're required to respond to the lawsuit, but she's having a hard time making up her mind about what to do. So notice how this problem is trying to push us to use our expertise. We want to balance that. She's sort of in and out in terms of being lucid about making decisions, but she knows that the clock is ticking, but just can't make a decision. Whenever we try to make her make a decision, she goes back to talking about the visits and the crazy boys and all of that. So we agree to represent her in a dispute with StormGuard without charging a fee. She has no living relatives, but she has a neighbor across the street, Mrs. Houston. She sees every now and then. So what makes this time sensitive is that in terms of our litigation strategy, we usually take an aggressive approach. We want to push back. StormGuard has been pushing our client, and we want to sort of level the playing field by doing something somewhat aggressive. We think that she should not pay any more money. We should file a counterclaim. But if we want to file a counterclaim, we only have a couple of days. Maybe today is Thursday. We have until maybe Monday. You have to file it within a few days. Trial date is in a week, though we probably could obtain a short continuance. So we have to file these papers by this coming Monday, and the trial would be this coming Thursday, a week from today. So we are going right after this class to see McKay and talk to her. And it's a good probability that she's not going to be able to decide. So what should we do? What should we do under Rule 1.14? Can we go to her later on today and say, look, you need to make a decision. This is what we have to do. This will protect your rights. And you may not fully understand it now, but this is what I have to do as the attorney. And we're moving forward. We're going to file this counterclaim. Just sign here. do that? I'm protecting your interests. You're waving back and forth. I have to stand up for you. This is the way I'm going to do it. Here are the papers signed, and we'll file them later on this afternoon. And I'll come back a little bit later before trial, and we'll talk about what I just did. But we have to move on this thing. So I'm trying to not label my client. Not saying she has 2 minutes. You just can't make this decision. I'm going to make it for you. File these papers, and I'll come back around and we'll have a good discussion about what I'm doing. I'm protecting your interests. Can I do that? It sounds, I'm doing a good thing, right? I'm protecting my client. So, what's wrong? And I'm not labeling Mrs. McCabe in any way. I'm not saying you have diminished capacity. I'm saying I am your agent. We have these goals. I know that we both want to push back against StormGuard. Now's the time to do it. The clock is ticking. I'm acting on your behalf. Just sign. Anything wrong with that? Or one approach would be, am I maintaining a normal client-lawyer relationship? Or am I being too paternalistic? Or maybe it's my job to be paternalistic if she's not making the decision. So what about this? A normal relationship may not be possible, so I'm going to direct her to file the counterclaim. Look, this is what we would have to do. That's what you hired me for. Sign it. Correct. Can we do that? Or better yet, what would you do? Ms. Paula, what would you do?
I guess I'm a little confused. Like, can you, if they don't have anyone close to them that can act as their entity, then can you not represent them as, I mean, I don't know what you do in that kind of situation, because if it was me, I think I would just kind of tell her her best option and just urge her to take it, but I don't know if I want to do that.
Oh, yeah, but that's good. So, tell her the best option. How would you sort of express that to her so that you're not overbearing and she's making the decision? That's the thing.
I think just give her like more than one plan, but kind of show her the benefits of one and how they kind of overshadow the other one, so she can still make the decision. But maybe if you're pretty clear about which one's the better one, she'll just choose that.
Yeah, and so you sort of make sure that she has all the options. Emphasize that we're under tight time constraints, and we might lose our ability to get your story out there if we don't take action. But you're right by focusing on, well, it almost seems like she's all alone, so we really have to balance using our will to make her make a decision, because we want to preserve client autonomy even in the face of diminished capacity. Keep in mind, Ms. Houston is there as well. We're going to see in the real case she comes around, but Ms. Houston, the neighbor, might be able to give us some help. Mrs. Johnson.
I was gonna say it's kind of tricky because
A little bit loud.
it's a little bit tricky because the counterclaim would also kind of go to her capacity. I think if that's like the route.
Tell me
we
about
should-
that. Yeah, what do you mean?
I mean, if you're gonna say like she didn't have the capacity to contract with them because she spent most of her savings on windows she didn't really need, like that would probably be the basis of the counterclaim. So I feel like you would have to like communicate that to her, which would be hard, and also I don't know how it would play in with this rule really, but
Well, so if I were drafting this counterclaim, I would try and stay away from her decision-making decision-making capacity and focus more directly on what the company did. I mean, they botched all of these things, and so then my argument will be, why should we pay for it? I mean, the windows are leaking, there's damage to the wall, you're unlicensed. All of those things say that you can't collect money if you're unlicensed from a customer. So all of those things focus on workmanship without her capacity coming into question. Now, of course, if I set it up that way, that underlying question that you're highlighting is definitely going to come out at some point. So that's some type of risk that we're going to have to look at, because they're going to ask, what did you sign? What did you think you were going to get? Was there mutual assent? Did you agree to this? All of that, and what was wrong with this? What was done by the contractor? So yeah, that would be that. So what do you think? Maybe we don't direct her because that would be too pushy. What about just telling her you have to make a decision? Tell her what we think she should do, and don't force our views on her. And then maybe, as Ms. Paula says, get the different options and you pick one. That might work. But are we so far that maybe we need to appoint somebody? Would a guardian ad litem be too much? Because do we have time just to wait? Yeah, go ahead.
I mean, how much are you supposed to like test her out?
Yeah.
In, like her capacity, because she can't even tell you how much she's paid, or she came on the contract. So like, how would you draft a counterclaim if you don't have any of that information, like any of those facts on hand? So I think if she's unable to produce any of that stuff, but you think that something happened, that's when you start exploring the GAL to see if like they can assist you in getting that, and then maybe file a counterclaim, because she doesn't seem like she can get anything together.
Right. That's good. So notice this. What we did was we went to what an attorney and client can do together. And if we have a client who can't even tell us the basis of the counterclaim or the facts that would help her case, that's a problem. And so if you're in this situation, you want to look at comment 5, and that's going to help you make, I mean, it's not going to cover everything. This isn't exhaustive, but we are saying now that we can't maintain this relationship. We have asked her to be engaged. We've asked her about documents. We've asked her about claims. We've asked her to make some type of decision about motion practice, and she can't do any of those things. So our next step will be consulting with family members. Maybe she doesn't have any family members. Maybe we can sort of use a reconsideration period, but we're under time pressure. And so in taking protective action, the lawyer should be guided by such factors as the wishes and values of the client to the extent known. So we know that we want to defend against storm guard, the client's best interest, and the goals of intruding into the client's decision-making autonomy to the least extent feasible. So no real answer there, but if she cannot make decisions, then we need to talk to someone else. And I think we might be at that point. Maximize client capacities and respecting the client's family and social connections. So once we make this decision that we have to take protective action, we consider all of those things. We might have to talk to Ms. Houston. If we say the client cannot adequately act in her own interest. So, we have the Department of Social Services, maybe Ms. Houston. We could talk to Ms. Houston about McCabe, but we would reveal information about the client only to the extent reasonably necessary to protect the client interest. That maintains the client's autonomy and privacy. So another thing that should bother us is that when we involve a third party in an attorney-client relationship, that's going to cause some disruption, whether we're on the same side or not. And that's going to cause some disruption. What do you think actually happened? like most things in life, things sort of unraveled and got a good result in quotation marks, but just the ramifications are devastating. So there came a point that we are now in terms of talking about this problem where we find that McCabe just can't handle this situation. And this is a clinic case. I think once the students went over to her home and they just found her staring at an open refrigerator. And so they became concerned because they're worried that she might fall prey to other salesmen, that she might not get enough food and care, no one to look after her. So the students contacted the Department of Social Services. She was then visited by a government social worker who decided that she was unable to look after herself. The social worker contacted neighbors and persuaded one of them to petition the court to become McCabe's conservator. That was Ms. Houston in our problem. The law, notice this, so in terms of representation, competency, area of expertise, scope of representation, the clinic did not represent Mrs. Houston in the conservatorship petition. That was beyond their level of expertise. So they found a separate free counsel to represent Houston in this proceeding. They did not defend McCabe from the conservatorship petition. I mean, they're on the same page. This is a client who doesn't have decision-making power. There's nothing really to preserve in terms of client autonomy. So they get a separate attorney to petition for the conservatorship. In the meantime, the students persuaded the creditor to hold the litigation in abeyance during this conservatorship proceeding. After the court appointed Houston as conservator, they authorized the students to file the counterclaim about the workmanship. They did that. On the basis of this counterclaim, the basis of the counterclaim was that since StormGuard was an unlicensed contractor, this was in D.C. Under D.C. law, the consumer was entitled to refund of any amount she paid the contractor before the work was completed. So while all of this was going on, McCabe's health deteriorates. She becomes unable to live independently. Her savings are becoming depleted. So then Houston, as conservator, sells McCabe's house and moves her into a nursing home. The proceeds from the house sale help maintain her in a nursing home. Eventually, the clinic recovers all of the money that McCabe had paid to StormGuard. And that money, again, was used to help for McCabe's living expenses. But the unfortunate and sad thing is that by the time that they won this case, McCabe was unable to understand that she had been victorious in this action. So notice this request for $900 in small claims dispute, and the client would request our help, resulted in all of these sort of life consequences occurring. And now, since she needed the care, I guess that was a good result, but certainly was not one that she intended. So, recovery of all the money, but look at all of the consequences. So that was vinyl windows. Now, look on page 240. So one limitation about this rule, some of you taking family law, is that when we talk about diminished capacity, we just talk about minors, but really treat the minors like adults almost. And so there is no specialized standard to take into account that you're in a different context when you're representing minors, that different interests and standards are at stake, best interest of the child, those type of things. But the rule really doesn't reference that. Under 1.14, we just have a mention of minority. That's it. And so the book makes the point that on page 240 that the rule really lumps everyone together without the nuance and specialization that you would need to recognize that juveniles are different, both in terms of their needs and the context in which their matters occur. So one reference that is made here is the ABA Standard of Practice for Lawyers Representing the Child. This was a set of model standards that was used to say you're in a different context, you have different interests when you represent a child. But the major thing that should be emphasized is that this notion of client autonomy carries through when we're talking about juveniles. We want undivided loyalty, we want to preserve confidentiality, we want competent representation, and we want advocacy for the child's best interest. So in that manner, this undivided loyalty, confidentiality, and competent representation, in terms of that reality, the child is the same thing as an adult client, but these standards are used to sort of recognize that children's issues come up in a different context. But all the time you're trying to preserve client autonomy. There is a duty, you see on the top of page 241, to protect client confidences indefinitely. So just because the lawyer-client relationship terminates does not mean, oh, I'll wash my hands of this, I can say anything I want to. That goes on indefinitely. I think that's comment 20 to rule 1.6. There's also this notion that on page 242, after the termination of an attorney-client relationship, you can give back what the client is entitled to, papers, that type of thing, return money that you have not done work for, all of that. But your own internal interpretation, say you keep a diary log of your assessments of clients and how they interact with you, the staff, and how they assess situations, and it's sort of like a personality strategy internal file that you keep, and the client wants that. No, that is protected. That is your impressions, and the lawyer may refuse to return that. Not entitled to internal papers. The lawyer may also refuse to return original documents when there is an unpaid bill, but you can't do that in a way that is heavy-handed and looks like extortion. You have to sit down and explain to the client that non-payment it seriously impacts the attorney-client relationship, and the lawyer may retain the documents that he created for the client. But notice there's this language, you can retain it, but retention cannot be unreasonably harmful to the client. Now, if you look at one last thing, Rule 1.16, declining or terminating representation. So if you look at this rule, so now we've sort of looked at the total attorney-client relationship, and now this is what happens when the relationship ends. So it says, except as stated in paragraph C, and paragraph C says that a lawyer can be compelled to stay on the case when ordered to do so by the tribunal. But except as a lawyer shall not represent a client, or if the representation is began, shall withdraw from the representation if. So this is mandatory withdrawal, let's put that. Violation of law. So if your representation will result in violation of law, that's comment two. I'll just put impairment. The lawyer cannot function as a lawyer because of some physical or mental impairment. The lawyer is discharged. So the client says you're fired, that's mandatory. So those are the three instances where withdrawal is mandatory under 1.16A 1 through 3. You continue representation and it's a violation of law. You cannot carry forward the representation because of some impairment, or you're discharged. So this is shall. (1.16B) is permissive. So there is several things. Lawyer may withdraw from representing the client if, this is under B, B1, and this is the broadest, if you can do so without material adverse effect on the interests of the client. Or 2, if the client persists in the course of conduct involving your services being used in criminal or fraudulent conduct. So we know that we've set several different rules saying we can't do that. So permissive, may. You look at comment 7, it talks about all the permissive. So the broadest is you can do it without material impact on the client, or 2, our services are being used for crime or fraud, and the client persists in that, or 3, the client has used our services and we find out about it. 4 is the client insists upon taking action the lawyer considers repugnant. Now that's sort of a falling out between attorney and client. The lawyer has such a fundamental disagreement with the client that representation cannot go forward. That's 1.16B4. And then 5, the client fails to fulfill a substantial obligation, like money. 6 is an unreasonable burden. So say you're a civil rights law firm, this is under 1.16B6. If it will result in an unreasonable financial burden, this litigation has been going on for 10 years, it's not getting anywhere, it's taking up all of your time, not getting paid, and it's impacting your firm's bottom line, permissive withdrawal. And then there's other good cause as well. So let me, I just want to highlight what comment 7 says about permissive withdrawal. So it says optional withdrawal. So through B1 through 7. But if you look at comment 7, so it just says we can withdraw in some circumstances. And then it just goes through 1 through 7. So what comment 7 really highlights is the factors under 1.16b where it's optional, but you'll see in each of those scenarios the lawyer is exercising his discretion. Very broadly, if we can withdraw just if there's no material impact on our client, all the way to good cause for withdrawal. And that's the discussion starting on page 243 all the way to 247. Now, one final point is you just don't, well, I'm going to withdraw like that. You have to try and have that discussion with the client, give that client some notice, and then if things don't work out, then that's how you withdraw. That's the discussion on the latter part of this chapter. Page 246. So that is the attorney-client relationship. So having that basis of understanding of what that relationship is and how it can end, we're going to start first talking about conflicts with current clients, and then we're going to move through and talk about former clients, specialized conflict rules, the revolving door, private lawyer to government practice to private lawyer. That'll be happening a lot in the next year or so, just as administrations change during election years. And then just an overall discussion of how conflicts work. But today we're just going to start with the building blocks of confidentiality. You look on chapter 6, starting on page 249. That's where we are. So the conflicts that we're going to be dealing with in Rule 1.7, current conflicts. What we're doing and who we're representing impacts the representation. And you see on page 251, those are the basic scenarios. Best of all possible worlds, when we're distinguishing these facts, and they're going to be fact specific, when we're distinguishing these facts, we might be in a situation where we don't have a conflict. Then we don't have a problem at all. That's fine. That's great. But, and what will concern us in this chapter, there could be a scenario where we do have a conflict. Now, that isn't the end of the analysis. Just because we have a conflict does not mean, oh, we can't represent that person. The conflict may be consentable. In other words, after we inform the affected parties about this conflict, they understand everything and we've laid it out. They give informed consent. We still can represent. That would be fine. And we're going to see that is the way that 1.7 is set up. But there are some conflicts that are so severe that even consent cannot save. say for example, you represent, whenever you have a joint representation, you're going to be very conscious of conflicts. Because even though you are united in common purpose, there could come a time when those interests diverge. Always happens. So we're starting out trying to win against the prosecutor in this criminal case. But things change when the liberty interest is on the line. So say you had a joint representation in a criminal case, and both parties consent, and everything's going along fine. But as things sort of develop, you find more information, and it's clear that client number 2 is guilty, and that this united front isn't going to be beneficial to client number 1. And you have a decision to make. And so you continue this joint representation, and you sort of fully inform the clients. You continue this joint representation, but you make the decision to throw client 2 under the bus in order to save client 1. And it goes all the way up through appeal, and then your argument throughout these proceedings is that both clients consented. In fact, one of them recognized that he would be sacrificed, but that was fine. He thought that maybe the prosecution couldn't prove everything beyond a reasonable doubt anyway, and client number 2 and client number 1 give informed consent, in quotation marks, to this joint representation. What do you think the court will decide on appeal? And I'm in trouble, but I say, no, this informed consent. I told him all about this, and client 2 said he wanted to do this, he consented to this, and that's fine. This was a risk that we decided to take. Informed consent, no conflict. What do you think the court will say? In other words, would informed consent save me from being disciplined because I continue the representation in the face of this conflict? And I would say, well, no, I have consent from both parties to do this, so it's okay. Is there a situation where a conflict is non-consentable? Yes. Is this one of those instances? What do you think? What do you think? You look at the top of page 251. Is that sort of conflict that I just described so serious that even consent doesn't save it? There are some cases like that. What do you think? You think a court will say that that's okay, that's informed consent? Yes? You have to be careful. What I want to illustrate is that an informed consent may not always remove the conflict. And the court would probably say that goes to the court of representation. You're almost asking a defendant to waive a constitutional right of confrontation and expose himself to criminal liability that could result in a long jail term simply because he wants to take the risk that the prosecution can prove each and every element beyond a reasonable doubt. You have a client actively acquiescing in self-sacrifice so that the attorney can pick one client over the other. And that's going to be sort of a clear example of a conflict. We're going to do a variation of something like that as one of the problems in this chapter. So There are some things where we don't have a conflict, there's some things where we do have a conflict, but it's consentable, and then there's gonna be some scenarios, rare, because most things are consentable, rare, where the conflict is so fundamental, so destructive to the attorney-client relationship that it is not consentable. Conflicts that are so serious that even consent would not solve the problem. And the lawyer should turn down the second client. So we're gonna do current conflicts. Then we're going to look at different types of particular current conflicts in chapter 7. We're gonna then do successive conflicts where we look at former representation and what we are representing currently. Talk about imputation a bit. Then we're gonna talk about the client and lawyer's self-interest conflicting, that's chapter 9. And then chapter 10 talks about present and former government attorneys and how they move over. So, somebody tell me how Rule 1.7 works. It gives us a definition of what the conflict is. And then tells us even if there is a conflict, it may be consentable if we can make these, if we can meet these requirements. So except as provided in paragraph B, paragraph B says even if there is a conflict, it may be consentable, and here's how. And I'll just paraphrase, look at this. A lawyer, mandatory, shall not represent a client if the representation involves a concurrent conflict of interest. So how do we know if something is a concurrent conflict of interest? The rule tells us a concurrent conflict of interest exists if representation would be directly adverse notice this, directly adverse to another client. So you pick up this one matter currently, you represent, and then there's someone else that you're also representing around this time, and what you do would be against that client. Directly adverse to another client, or so this is the most direct kind. You are actually going against the interest of one of your clients. Bad. Undermines undivided loyalty. The client will feel like he or she is betrayed. You're actively going against someone you are supposed to represent. Follow those building blocks that we talked about before. So we shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if taking the action would be directly adverse to another client, or sorry about that, materially limited. There's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. So that's somebody you're representing now, notice this, or a former client, or a third person, or by personal interest of the lawyer. So two types of concurrent conflict. Those are directly adverse to the interests of another client, or the things that you can do for a current client are limited because of someone you represent currently, someone you represented in the past, former client. We're going to talk about that under 1.9. Your own personal interests. Materially limited. So this responsibilities to another client, that's someone you still represent now. Currently. To another current client, you could say. To another client. Notice this. A former client that's rule 1.9. And you're going to see when we talk about former clients, we're going to have to do two things at the same time. We're going to have to look at who we're representing currently, and then we're going to have to look backward at what we previously done and see how that impacts this current representation. So that's what we're talking about, materially limited. So in other words, I'm representing an entity or a criminal defendant or anything, and I'm limited in what I can do currently by what I did in the past. That would show materially. I cannot fully consider all of the options. I cannot draft this transaction in this particular way because I've done something before that impacts the way that I can carry out my responsibilities. So responsibilities to another client, that's current. Responsibilities to a former client. Or third person. Or by personal interest. So we'll get into this personal interest and specialized things when we talk about Rule 1.8. Those are specialized rules of conflict. So thus far we know that a concurrent conflict can be directly adverse to another client. And if it's not that, another way a conflict arises is if you are materially limited by your responsibilities to a current client, a former client, some third person outside of the attorney-client relationship, or by the lawyer's personal interest. So, someone tell me a little bit more about directly adverse. So I represent a client in the Title VII employment discrimination. So I'm representing the plaintiff in that action. And then there is a auto accident, and I take on the case. And I've done all of the checks and everything, but I just don't notice the name, or maybe the name is misspelled. So I'm representing a client in a Title VII action. It turns out that I am against the same client in an auto accident case. And so I, a little bit rusty on PR, I've been practicing for years and years, but I say I just do it by common sense. That's totally unrelated. In other words, I'm representing employment discrimination under Title VII, that's fine, I'm representing this client, but I'm also suing this client in a personal injury automobile case. No conflict, right? Because it's unrelated. Right? It's matter.
That's directly adverse because you represent both of those clients, even in unrelated matters, and if you're representing one
Okay, that's good. So, but why can't, this is what gets people, even people who practice law. Well, I'll just use common sense. That's unrelated. My client shouldn't feel, this is advancing your rights under the employment discrimination, and this other thing, that's the auto thing, that's unrelated. But I guess what really we're concerned about is you're for this client in one action and against the client in the other action. And that's what makes it. And so we made a big deal. This is why we made a big deal about undivided loyalty, protecting confidences, communication, diligence. You are all in for your client. And look at comment 6. This is important. Loyalty to a client prohibits undertaking representation directly adverse to the client without that client's informed consent. So I guess you could say, I'm with you on this Title VII, but this auto thing has come up. Can you give me informed consent? I think the client would say, no, I think that's bad and I don't want to do that. But you could if informed consent was given. But absent informed consent, a lawyer may not act as an advocate in one matter against the lawyer represented in some other matter, even when the matters are wholly unrelated. So that's comment 6 talks about directly adverse. That's good. So this is a simple proposition. If undivided loyalty means anything, it should mean that the client should be confident that her own attorney will not turn against her in some matter, whether related or not. And then same thing for materially limited. So notice this, even if there is no direct adverseness, you have to go down to the next level too. Is there still a concurrent conflict? So you say, I know I cannot represent a client if there's a concurrent conflict absent informed consent. If it's directly adverse, I can't do it. And even if it's not directly adverse, I still have to ask the next question, may it be materially limited? So comment 8 says, even if there is no direct adverseness, you're not going directly against the client. A conflict of interest is this if there's a significant risk that a lawyer's ability to consider, recommend, or carry out an appropriate course of action is limited. Materially limited by the lawyer's responsibilities to someone else. So, and it points to the joint representation scenario. Which is classic because, notice you start off with a commonality of interest. Like in this upcoming problem, we want to beat the taxi cab company. That's the commonality of interest. But then the question is, what happens when interests diverge? So everybody starts off on the same page, but as we move through this litigation, then things might change. So you have a little chart on page 255. That's what we've just been doing. And then on page 256. So when you evaluate conflicts, I want to point this out. This is what we'll be doing. If you look at comment 2, it talks about how to evaluate conflicts. So this is going to tell us if something is directly adverse or materially limited. So, notice what it says we have to do. This is what we're gonna do in every case when we talk about conflict. We're going to clearly identify the client. That's one. We want to determine whether a conflict exists. That's answering this question. Is it directly adverse or is it materially limited? Then we're going to look at 1.7b. I'll just put 1.7b. That is, even though a conflict exists, is it consentable? Then if you went through 1.7, we'll do that when we come back. 1.7b, you have the requirements. Even though there is a conflict, the lawyer makes a determination, I can provide competent and diligent representation. Representation is not prohibited by law. I'm not on the same side of the V in the same action or claim. And informed consent. If all three of those are met, then it is consentable. So what comment 2 actually does is it tracks Rule 1.7 and tells you how to analyze conflicts. That's on page 260. So when we come back, we are going to start with the injured passengers on page 269. So look at 1.7 again, and then look at these two clients. Commonality of interest is they want to defeat the taxi cab company and show liability. But if you look at Jill and Rima, they are going to have different interests. And then the question is, how do you structure this joint representation so it can go forward? Have a good weekend.